Thank you, committee members. It's my privilege to appear on behalf of the Association for Reformed Political Action, or ARPA, where I serve as legal counsel. Thank you all for your thoughtful review of this bill. My remarks today will focus mainly on the hate propaganda provisions of the bill, but our written brief, which you may not have yet, also addresses the proposed hate crime and the intimidation offenses. ARPA is a Christian, nonpartisan policy and legal advocacy organization with considerable experience as a friend of the court in charter cases. ARPA believes that every person has inherent dignity as an image bearer of God, and that we have a moral duty to honor each other's reputations. That duty is reflected in our laws on defamation and criminal libel, among other areas, and that moral duty applies not only in relation to individuals, but to groups as well. Legally, however, group libel is more complicated. One danger, as our Supreme Court has identified, is that laws meant to stop malicious attacks on a group's reputation and basic social standing could be used to silence criticism of beliefs or practices associated with the group. So let me illustrate the difference. The late atheist wit and writer Christopher Hitchens called the Christian doctrine of vicarious atonement evil. Now, that is a core Christian doctrine. But Hitchens was expressing a moral and, one might even say, theological opinion, and he was rightly free to do so. Yet today in Canada, people are being accused, often by government officials, of promoting hatred simply for expressing moral or political views. My own organization, ARPA, was accused by the mayor of Hamilton for promoting hatred because we put up a sign that said, "Let kids be, end medical transitions for minors," and the city had it taken down. The city also claimed that another sign from a different group, which said that women are by definition female, also had to be censored due to hate speech concerns. Earlier this month, the British Columbia legislature condemned ARPA as hateful for opposing medical transitions for minors and for supporting moderate pro-life laws. A BC government MLA even told a very sad story, about a same-sex couple being harassed in a public place, and then called ARPA and its supporters the harassers in that story. Blatantly false, but I guess justified because Christians hold the traditional view of marriage. Now, the member's statement, to be clear, defamed and vilified Reformed Christians as criminal harassers, which seems like a way, frankly, to stir up hatred against this group, while at the same time accusing these Christians of promoting hatred for the views that they hold. I trust I don't need to point out the hypocrisy. This kind of ideological bias is what the Supreme Court warned about in Keekstra, and which Parliament must guard against here. Bill C-9, with respect, risks blurring the long-established definition of hatred. If the goal is simply to codify the common law, then the bill should mirror the stringent tests set out in Keekstra and Woodcott. Those cases caution against two key errors, among others. First is focusing on the content of what is said rather than its anticipated harmful effects. And the second is focusing on the feelings or views of either the accused or the victim group. Bill C-9 risks both errors. First, it uses hatred in one place to refer to the feelings that the accused intends to promote in others, part of our established test. And in the new hate crime offense, it uses hatred in reference to the accused's own feelings and motives. Second, the bill's clarification clause blurs whether courts should consider the feelings or views of the identifiable group by using the words solely hurting, humiliating, or offending. ARPA therefore recommends that the committee either remove both the definition of hatred and the clarification clause to make clear that the common law standard still applies, or amend both to clearly reflect Keekstra and Woodcott. Hatred could simply be defined as an emotion of an intense and extreme nature that is clearly associated with vilification and detestation. The clarification clause could say that it is a statement is not criminal because it is considered offensive, repugnant, or distasteful, or because it ridicules, belittles, or affronts the dignity of a group. And those are both phrases taken from Keekstra and Woodcott. Because of the analytical pitfalls I have noted here, and others that the court has warned about and that you've heard other witnesses highlight, the requirement for Attorney General approval should remain. As an intervener in a hate speech case, I noted the Crown making some troubling arguments, again, going to the substance of the views, the person's moral views, rather than what they're trying to promote, right? The emotional reaction they're trying to promote in others.
Sikkema, you're at time. If you could just briefly wrap up in a few seconds.
For sure. Our main concern is that the bill set a sufficiently clear standard to protect groups from deliberate, vicious libels without creating a potential weapon for ideological censorship. Thank you, Chair and members.